The RNC case, working its way through the courts and thus not yet at the Supreme Court, is a basic challenge, what I would regard as a basic attempt to relitigate McCain-Feingold legislation, the ban on soft money and the party's role in soft money fundraising and spending, and the McConnell decision, where this very provision was upheld. I know the litigants bringing this argue that McConnell was only a facial challenge and this is an applied challenge, but the reality here is there isn't any difference. The facts that the court was presented with in McConnell were party soft money fundraising. That's exactly what they're now saying should be permitted. It was the national committees that were raising it pre-McCain-Feingold, and it was the national committees who were in that case saying we have a right to continue doing so, at least as it affects state elections. And if you're going to ban us from having federal candidates involved, you can't ban us from our right to engage in election activity in the states. And the courts basically, McConnell says, no, that's not what happens here. What happens here is instead Congress has merely said you have to use money raised under federal limits when you do activity in the states, just as when you do activity in federal elections, and that's constitutional. So they really are, I think, asking for a overturning of that piece of McConnell. I would note that there's obviously a lot of politics here. This case was not brought before the November general election, when John McCain was the nominee of the Republican Party. It was brought right after the election, when the RNC didn't care what John McCain thought of them, and when the litigants in this case were also litigating who was going to be chairman of the RNC, and I think this was part of the battleground over there on that. So, you know, our view is that soft money is still the same danger that it was before. Nothing has changed. The argument that somehow only having party officials raise it makes it acceptable is not something that the court accepted in McConnell, and I think as a practical matter is simply not realistic. For those of us who've seen Washington, you know that if the chairman of the RNC asks you to do something, you're going to feel that's being done on behalf of the party and its prominent office holders. And there's nothing to prevent then the chairman from saying, you know, our Senate minority or majority leader is really grateful or hopes you'll do this or would love to meet with you, etc. So enough of that. That's the RNC case working its way through. Finally, and my timeout has already been flashed at me, so I will be quicker on speech now, partly because it's still working its way well through the process, but this is not only this is a case that potentially is a fundamental challenge to the Buckley v. Vallejo case itself and the dichotomy between unlimited expenditures and the constitutional permissibility of limiting contributions. And you know, you can argue about whether this is a piece that never got decided in Buckley or not, and all the legal scholars will point to various footnotes in other cases, but the issue here is going to be, is this a contribution, in which case it can be limited, or is this speech that can't be limited? And I think the best reading of that is going to be that it is a contribution because it is given to someone who then makes the decisions about how to spend it. And it's fundamentally different from an individual going out and spending his or her own money. The other piece of this that I would leave you with is an argument is made, well, if it's independent, then there's actually no coordination with candidates, there can't be any corruption. Again, with due deference to FEC commissioners in the audience, the coordination regulations, those of us who've worked in the area know, are a complete minefield, whatever version they're in nowadays after various court decisions. The FEC has had a terribly difficult time identifying coordination, investigating it, coming to an agreement about whether it has existed. So I would just say what you and I mean by coordination in a common sense way, and what we claim doesn't exist in these independent groups, is sometimes miles different from what the FEC will end up saying was or wasn't coordination. And it's miles different in a way that means you can have a great deal more activity, discussion, back and forth between these supposedly independent groups and candidates than you would expect without reaching the legal definition of coordination. So I think when you're looking at the constitutional issues in that case, you have to think about the practical ones as well, namely that there will be what we would all consider to be coordination, or at least the legal possibility of it, and that affects the outcome. So those are the three. I now turn this over to Allison Hayward for what I presume will be a completely different take on them.